Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 64, NYT Has No Pulse. Hello and welcome back to This Week in Law with Denise Howell. This is episode 64. We're here today with a couple of patent specialists. We've got Matt Buchanan from Promote the Progress and BIPO. Is that how we say your firm name?
BIPO. BIPO, either way.
I was thinking like WIPO. Anyway, Matt, great to have you back on the show. Thanks so much for joining us.
Thanks, Denise.
And also on the patent front, and I should commend you both for managing to write and opine about patent issues without calling any of your pages patently something. I think that's probably a huge challenge. We've got Steve Nipper. Hi, Steve. How's it going?
It's going good.
Steve blogs over at the Invent blog and has done for many a good year. So I've had also with us, by the way, let's introduce everybody before we start jawing away. We've got Evan Brown. Hi, Evan. How's it going?
Hey, how's it going? It's good to be here. And I'm here mainly just to make fun of the patent lawyers. That's what I do most of the time.
Thank goodness.
Glad to be here. Thanks for having me.
Hurl Floridian palm trees at them from your current location.
Yes, I can do that.
Yes. So Evan, of course, is over at internetcases.com, and we have some very juicy internet and patent issues to talk about today. I've had Matt and Steve waiting in the wings here for weeks now, waiting on the Supreme Court's Bilski decision, which still hasn't come out, but I'm sorry, I just couldn't wait to have them on the show any longer. So we're going to talk a bit about Bilski today, even though we don't know anything more about it. The Supreme Court hasn't ruled. And we'll, of course, hopefully they can see their way through to coming back on the show and telling us what they think about the case when it actually comes out. But we certainly have other issues to talk about on the patent front this show. And also, but before we get into any of that patent stuff, I hope you guys don't mind. I know you will happily talk about other technology law issues. I have a real copyright thing that I've been dying to discuss, and I'm afraid my fellow PTA moms just don't get as big a charge out of this as I do. So I've really been looking forward to getting you guys on the show and chatting about this thing that has happened with Pulse. Can we go there first, please, and chew through that?
Absolutely.
Yeah, just to frame, no pun intended, this issue for folks listening. There is a wonderful news aggregator that is available for the iPad through the iTunes App Store. And this thing is called Pulse, and it was put together by a couple of Stanford grad students. If you want the full backstory on this, Kara Swisher has a great post teeing it all up. It's in our show notes at delicious.com/thisweekinlaw/64, along with the rest of the stuff we're going to talk about today. So they've had this in the App Store since the get-go of the iPad launch. And it's one of the apps that has been featured a lot and very popular. I think it's topped the paid app roster in popularity a number of times. I actually had held off downloading it until all of this came about. So there's the Streisand effect for you in action. Get it a lot of media attention and it will spread even wider. But now that I have this thing, I'm really enjoying it. But the issue here is the New York Times senior counsel, known as Richard Sampson, sent off a nastygram to Apple about this app because for a number of reasons. Number one, there are screenshots of the Times site and how it's featured in the app on the page for the app in the iTunes store. And they're objecting to that, I think, on trademark grounds. But it's the copyright reasons they have cited that really have gotten my mental juices flowing. And basically what the Times is contending is that because this is a paid app, a paid news aggregator. And because of the way the Times content is appearing in the app, this is, according to the Times, infringement and must be stopped. So let's see, what other texture can we add to this before we throw this in?
Did you mention how Steve Jobs had kind of made a big deal about it at at the conference, WWDC?
Yes. Earlier this week when the iPhone 4 was announced, as Steve Jobs was basically basking in the glow of their iPad success. The Pulse app was one of the ones behind him on the big screen in his wonderful keynote deck. So it's definitely gotten a lot of play. Oh, the other thing I wanted to mention that's critical to at least the Times Council's analysis is the fact that this thing functions as an RSS reader, but like many RSS aggregators, it pre-populates with a few feeds so that you don't open it up the first time and just see blankness. It has a very nice built-in search engine. You don't have to know the lengthy, complicated URL for the feed. You just, put in what it is you want to subscribe to. It'll go out and find it and subscribe you. But it has pre-populated with a few feeds just to get people a start, and the Times is one of them, and the Times objects to that too. So, Evan, let's go to you first. And what do you think about all this? And how on earth are we getting to the point where the New York Times thinks that RSS aggregators are infringing on the material that they are simply making available through their feed? Oh, and the other thing I didn't mention is there's a browser built into this app. So users have the option of viewing the text of the RSS feed, which in the Times case is a very partial bit of information. It's the headline and the lead of the story, not the whole story. Or if you switch over to browser mode, you see the web page. So, Evan, what's the issue here, and does the Times have a foot to stand on?
I'll leave it to the New York Times to be raising an issue like this, in as much as the New York Times is the representative in this new media world of the old business model, wanting to make a few pennies off of each transaction. And Dave Weiner has a great post that is very critical of the Times, or at least does a good critique of it, not necessarily critical in a negative sense, but certainly is harsh in his criticism of the way the Times is wanting to extract a few pennies out of each little bit of content like this, not realizing the benefits of wider distribution of the content to get people interested. So all of that aside, if we set aside, the notion of how it's unfortunate that the Times is taking this approach and taking an action here that seems to be resistant or detrimental to the expansion of new media and an innovative way of distributing content like this through the App Store. If we set all those issues aside, when we look at the pure legal issues, I think the Times probably does have a leg to stand on. It's as simple as an infringement or an alleged copyright infringement arising out of using content outside of the scope of the license. The terms of service for the Times content, including the RSS feed, says that it establishes a scope for the use of the feed that shouldn't be for commercial purposes. And when it's wrapped into a commercial product like this for sale through the App Store, then that is a use that's beyond that scope. And I think most of the case law, even as recent and as new and as exciting as the Jacobson versus Katzer open source opinion. Obviously, this is not an open source issue, but when we think about this very hornbook kind of doctrine of what will give rise to infringement of copyright when it's used outside of the scope of a license agreement, I think that this type of use, if all these facts as they're coming to the surface are true, does seem to substantiate a claim for infringement, which would be good, which would support the DMCA takedown notice that the Times sent. And whether we like it or not from a cultural standpoint or a journalism, media theory kind of standpoint, regardless of that, the copyright issue might be pretty strong in favor of the Times on this.
I don't know if I'm with you on that. And here's why. We have, I don't think, and please correct me, any of you, if I'm wrong, I'm not aware of a whole lot of law about RSS feeds and the reuse of the content syndicated that way under a license or not. In fact, I'm not aware of any law. So I think we are in a great wide open space here about what an aggregator is and how it should be treated for purposes of the law. I think, personally, that aggregators are sort of the love child of web browsers and search engines. And in both of those instances, we have seen courts carve out exceptions for the copying that those bits of technology do in order to serve their function. And I think that an aggregator is in the same boat. It needs to be treated in a way that acknowledges that it is a utility, that it is very browser-like, and that, in fact, this one has a browser as part of its functionality. So, if you look at it through that framework, I don't know that licensing or, putting in a restrictive license or any sort of otherwise applicable overarching copyright really applies in the same way that, if you have a URL and it's accessible by a browser, you can display that page. I think if you've got a feed and it's accessible by an aggregator, you can display what's in the feed. I don't think there should be any real distinction there for purposes of the law. So, point one, throw that out to you guys. Am I completely off track here, or does this sound reasonable? Matt?
I actually think both sides at this point sound reasonable, because I think it's kind of a new area that we're venturing into. Like you said, Denise, with the browsers and so forth, we've ventured into it a little bit, but we're just kind of digging down this path a little bit more with this current situation. Personally, I don't think the copyright side of it is the most interesting side. I mean, if I were the Times, the thing that would bother me the most would be the fact that this is from my perusal of the article. I didn't actually see the website, but I think that they had on their website a screen grab of the Times or of the Times logo or of their brand somehow. And it could be construed that they were positioning the Times trademarks and brands and so on and so forth.
Right, as though they'd somehow sort of partnered with them or
exactly,
and endorsement of the app by the Times.
Right, it almost gives the feeling that, hey, we're the one that's distributing the Times content to the iPad. And for me, that's kind of the more problematic issue.
Yeah, I think for me that is the problematic legal issue. I think the copyright issue is problematic because it is unresolved, because there isn't a whole lot of case law we can turn to and look at. I know, if I were a lawyer embroiled in this or a court considering it, I know how I'm leaning as to how it should come out. What do you think, Steve?
Even with that, having that position where if it's out there, if it's available, it's fair game, would have if that was true, it would have a horrible impact. All of the blogs that are out there would be able just to repurpose everyone's content and reuse it. There'd be nothing you could do about it. So I don't know that I would agree that, if you put out an RSS feed, it's fair game for reuse in whatever purpose someone can make of it.
I've got to come back to that a splog is not an aggregator. We're talking about a type of technology that I think an exception needs to be carved out for, as with browsers, as with search engines. A splog is simply a kind of a web page that is doing its infringing. It's not a utility. It's not a tool that is helping people consume other web content.
But they went beyond just being a tool. If they were just a tool that was added to the App Store, they would have just put their app in the store and have it empty. You download it and it's not preloaded with any feeds. Mm-hmm. And then it's up to the end user. If I want to subscribe to the Times, I go grab their feed at that point. But I think it kind of changed when they put their aggregator in the App Store and they had those preloaded feeds in there.
Mm-hmm.
Yeah, that's where I see a distinction in my mind too, because Denise, we've been having this conversation for several years about the copyright.
Years and years, ever since RSS came on the scene.
Right, how it should be treated from a copyright standpoint, and I know that we have bounced around the notion several times of an implied license, and I think we at least implicitly rely on the thinking of the court in the Field versus Google case, which was one that held that there was an implied license for web content that's put out there, especially when you know how to put a robots.txt exclusion header on an HTML page and all that stuff, and you don't do it, and people and Google still puts it into the index. Same way with an RSS feed. I always like to say syndication is RSS's middle name, even though that's not technically correct. It's just nice to say, because it is so critical.
Actually.
It is. Well, either simple or something like that. That's what you put RSS, out there for, a feed out there, so it can be picked up by a number of aggregators, not just Google Reader, not just Blog Lines, not just Feed Demon, if that's even still around. I forget.
Right.
All of these things are out there, and you want it to be picked up because you want it to be distributed. The thing that really just and so I'm with you as far as saying that it ought to be out there, and I think that most publishers put have an implied or have somehow granted the world an implied license to pick it up into various forms of aggregators. The thing that's just different about this is that it's packaged up and it's it's sold as a bundle, and that to me seems to be the thing that takes it outside of that use that one would either permit impliedly to the world or even expressly in the form of these terms of service. So I think we're probably looking at the problem the same way and with the same kind of values. I think a real challenge is just to figure out where to put the sliding scale, where to stop it on all of that, to figure out what's equitable.
I would love to know, in the App Store, there's an interesting thing. You can't unbuy an application. There's no trial period, or, easily you can anyways. But I would love to know how many people pressed buy for that application and gave Apple their $4, thinking that they were buying the New York Times app or their content.
Yeah. I mean, that's an interesting thought bubble to float out there. Personally, I think as far as enjoying the Times content, the Times has done a nicer job with their own app, simply because their RSS feeds are so restricted. The feed that appears in this application, Pulse, doesn't become, it doesn't let you sort by topic, the subject matter of the paper. I want to be reading the tech articles more than I want to be reading some others. And it doesn't do that for you. It's just a straight river of news. Whatever comes through on the feed is what you see. And also, if you're just looking in the text-only view, you see a very little bit of text. And it's not until you go to the web view that you see the whole page. And that's the other thing I want to talk about here. Before we go to that part of this discussion, though, let's Marty Schwimmer and I have been emailing back and forth on this morning. You might remember, Evan, I think you will, that Marty actually had a dispute with Blog Lines a while ago, years ago, about their putting ads around his material in their aggregator when his was only licensed for non-commercial use. And Marty will have to remind me how that all came out. I think they simply removed his feed and he was happy, and there was no actual, push comes to shove, what are the actual legal standards involved here? But Marty did take that stand. And what he says now about this licensing point, he was running out the door, so he really couldn't get, a full-blown opinion to share on the show. But he says, all I will say is making one's content available through the web creates an implied license to allow reformatting in the way in which browsers reformat, while total news represents what is not covered by an implied license. And lawyers can discuss what lies between those 2 points. I'm not aware of cases. So that total news is what I alluded to a moment ago, question about framing, which was also raised by the lawyer for the Times. And let me show you exactly what Pulse does, if I can here. So you're looking, here's the app. Move that in front of the camera here. Okay, that's its main view. These are the stories. There we go. Your various sources go up and down, and then for the particular source, you're seeing across. Okay, so all the Times stories are displayed across. And you just see the headline and a bit of the lead. Then when you click on it to see more, you see this very small bit of text over here when you're on text only. But then you click to web view. And I don't know if you can see that very well, but you're in a browser. There we go, that's better. In a browser that is showing you the actual Times site, just as you would see it in Safari or any other browser, Opera, etc. So one of the things that Mr. Sampson complained about is that what I just described to you is framing the site. Evan, what do you think under total news? Is this what we typically think of as framing?
Well, it's clearly a little bit different of an interface, but conceptually, I guess it is, because you're bringing it in. You're bringing in that HTML content and putting content around it. It's been a long time since I've actually built a web page that has frames in it. I would have to go look at the reference manual how to do that. But I
think we're past that. This isn't a web page. it's all under Apple's standards for developing applications. It's all whatever's in their SDK.
But it's content coming from New York Times, right? I mean, it's something that's coming from them and stuff that they would have developed or they would present in a certain way, and isn't it being brought in? Maybe I'm just not illuminated, technologically how it actually works here. But it seems like there at a certain level, there's an isomorphism between this and HTML being brought in a frame, which I guess takes me to another question then on the copyright analysis. To what extent is there a copy being made here? And that's something that I just don't know, because I don't know how the application works, how the content's delivered up. Is there, is the New York Times content being cached somewhere other than, and is it being presented other than anywhere else other than straight from the New York Times server? If so, that would play into the copyright analysis as well.
Right. I don't know the answer to that. I don't know how the WebKit works that is included in the SDK that is used to make apps. But from my perception of this thing is it's simply a little browser add-on that you can include. And it's, just as though you were running Safari or Opera or anything else within your app. It's just, a mini browser that Apple gives you the ability to code in. And frankly, a lot of aggregators do this. We've talked about, we've featured one on the show before, I think. SkyGrid does the same thing. It aggregates, and then when you click on the whole story, it actually doesn't give you a text-only view. It gives you simply the web page that you're viewing in the other pane. And Superflesh in the chat room pointed out, I've already logged out, so I can't do that without taking a lot of time. But if I had just simply tilted the iPad into portrait mode, the framing, quote unquote, goes away because you don't see that other half of the screen anymore. All you see then would be just the Times webpage.
I think bringing up the whole Marty issue is perfect, because if you take that app and you replace all of that stuff on the left side of the screen with advertisements, it's the exact same thing Marty was upset about. It is the exact same thing.
But it's not. There aren't advertisements in this app. They're charging a fee for it, just like you might charge a fee for a really cool browser that you built if you thought that someone would actually pony up for another browser. But there are not ads throughout this thing. You've paid for it, so I think thankfully they're keeping it free of ads. Now, if they had made it free and there were ads, which I think maybe SkyGrid does do. I can't remember off the top of my head, but I'm sure there are aggregators in the App Store that are free and ad supported. Then, you're more in that Marty situation. But, again, I'm not ready to buy off on the fact that aggregators shouldn't be treated like browsers, and that the law needs to start taking that into account. If any of these kerfuffles over using material in an aggregator get to court, I hope we get to a point where those arguments can be made. The other thing that I thought was pretty interesting about this was Kara Swisher has reprinted the whole letter from the lawyer And one of the things he mentioned, actually, it was Kara who mentioned this. It actually didn't come up in the lawyer letter, but she thought it might be an interesting point in a legal analysis, and I think she's right, that the funny thing about all this is that another New York Times journalist who actually appeared on This Week in Google earlier this week, his name escapes me now, I was watching it this morning, but he had written a glowing review of this application for the Times before the Times actually sent out its letter. So in his review and description of the app, he pointed out that in order to, that this application builds in sharing. So if you want to tweet it or put it on Facebook, et cetera, it's a couple of clicks and you can do that. And what Kara thought was interesting is, oh, well, the New York Times has its own sharing tools and presumably wants you to use those because then it can track, how many times something has been tweeted, et cetera. So it was Brad Stone. Thank you, Sharp65 in the chat room. So here we go. Do you think, Evan, that circumventing somebody's sharing strategies would be actionable in any way?
It's a good question. When we talk about circumvention, I mean, naturally, the thing that comes into mind is, the DMCA, Section 1201, the anti-circumvention technologies. And it doesn't seem like there's, again, this is a point where I need to, have a more of a primer on the technology that's actually going on here. But, if you're not cracking DRM in some way, and, you're still able to bring that content into where you want it, and we can satisfy ourselves that the copyright infringement issues are kosher, then still an open question for me whether circumventing someone's sharing strategies that way would raise a question. This is a great topic because this is one of those areas where there's so much innovation going on. Content is being delivered in ways that we're not used to, and there are people who are riding that wave. Pressing the envelope on all these copyright issues. I love it. Yeah.
Well, I don't think again that it's as big a deal, or it should be, this whole notion of bypassing sharing tools, because we've already been through and there is case law on whether you can freely link to things that are out on the open web, and I think that that's what's going on here. Somebody's making a short URL and linking to the Times page and sending it out to Twitter or Facebook or wherever people want to share it. So I think you would have to hurdle the fact that we've already decided from a policy standpoint, it's okay to link. You can link. Go ahead and link. Okay. So I think that this one doesn't go very far, but it's one of those things where you're right. It just it seems new because of the platform. I think it's because we're talking about a device and an app instead of a browser. And I don't know. Let's see, Steve. What do you think about this? You can tweet it directly from the application.
Yeah, and that opens up a whole bunch of, a huge can of worms, and I don't know. I think at some point they start really damaging themselves through making these attacks. So I don't know that I would counsel them to take that kind of an approach.
Yeah, I think that we're gonna cross some of these bridges soon, and I don't think it's going to be here. I think that these folks are going to do what they need to do to keep their application in the store and not drawing fire from the Times and other copyright holders. But who knows?
It's a great question. It's a great question about any kind of contractual limitations you can put in the policy as to how it can be used. I think it was Kevin Heller years ago when he was dealing with a splogger had put in an agreement in his policy for his RSS feed that if you repurposed it, you had to pay him $30 for every post or something. And he didn't follow up on any of that in dealing with it. But it's a great question whether or not you can actually put what is the meaning of the limitations from a contract standpoint that you can put in a policy. So we'll see.
Yeah. I think it's fascinating, and I'm looking forward to some law actually getting made on some of these issues in this context, where we're not dealing with trying to apply cases from 15 years ago that don't necessarily work here. I will toss out one thing that occurred to me as all this was breaking was a few years back, I got pinged by Amazon, who were in the process of pre-populating what was going to be available in their Kindle store for folks to put on their Kindle. And the first salvo from them was couched in terms of, hey, we see that you have an RSS feed, and we'd like to use the material in that RSS feed in our store. And we're going to, sell subscriptions to what's in your feed for X amount. And, my immediate response was, yeah, so my feed is licensed for non-commercial use. So we're going to have to cross that bridge, at which we did. And I'm not sure how that all played out with other people who were included in that initial launch of the Kindle store. But, what wound up happening was documentation and acknowledging that there was, a right here for which a license needed to be granted, even though I already had a Creative Commons license applicable to the work. Now, I think the distinction there is that the Kindle is a device that maybe functions as an aggregator, but is not an aggregator. It's a device that, I don't know. It's hard. It's hard to really make that distinction. You go and you populate it with the various feeds, and then you pay for them. So I guess the distinction there is you're paying a la carte in addition to paying for the cost of the device itself.
I would suggest you just ask the PTA moms on that one. They'll have some insight.
Yeah,
I realize that's the point where your interest with the other PTA moms converged on that one right there. So.
Yes, no, they reconvene when people are coming to me and asking me how they can track their kids' cell phone usage.
Right,
seems to be a very popular topic.
There's been some interesting stuff going on in this conversation. You were talking about Marty's issue with blog lines. That was probably back in 2005. And Steve, you mentioned Kevin Heller. He's still kicking around out there, but Tech Law Advisor was one of those really early law and technology blogs. When I think back of those days, I think of the Halcyon days of Rethink IP. Denise, do you have any idea what happened to those guys? Write that blog?
Yeah, I do, in fact. Hi, guys. How are you? Yeah, I pulled up Rethink IP when we were prepping for the show, and it has sort of been languishing there. Do you have any plans to post there again?
I'll defer to Steve on that
one. No, I think, who knows, we might repurpose some of that content later, but I don't know.
Yeah. Maybe we could charge.
I think for a project, it's kind of dead. So,
all right. JMath in the chat room says Gina Trapani on Twig made the point that New York Times could easily exclude the offending aggregator's use of the RSS feed by including an exception in the feed. Now, I don't know exactly what that means. Does that mean the Pulse reader would simply choke because there's some kind of anti-Pulse code in the feed that it would trip on? I guess. I mean, if there's a technical way to block out aggregators and you don't want your work to appear in an aggregator, I don't know what the purpose is of having an RSS feed if you don't want your work to appear in one aggregator versus another. But okay, sure. Or you could just not publish the feed. So, so Superflesh says she was talking about robots.txt, which is a search engine exclusion, right? Mm-hmm. I don't know how that plays into.
It is, but I think the aggregators,
RSS.
I think they identify themselves too when they pull the feed. So yeah, there might be a technological way to block them.
Right.
Something analogous in action.
So again, you're left with the situation of you're publishing an RSS feed, but you don't read it. Okay, fine. Yeah. You can live in that world if you'd like.
Yes, you can have your cake and eat it too.
Alrighty, so let's talk about this Bilski case and why the heck we're so excited for it to come out from the Supreme Court. I will say I was just perusing an article I don't yet have in the show notes by Gene Quinn, who blogs at IP Watchdog. And what he says about Bilski, and I'll ask our patent guys if they agree, is, where did my little quote go? It is not at all an overstatement to say that the fate of future innovation in the United States rests squarely on the Supreme Court getting the Bilski ruling correct. And then he goes on to say what he thinks should be correct. You guys concur that it is that monumental, and can you remind us all why we are waiting so impatiently for this to come out? Steve?
I don't know that it's all that monumental to the future of innovation. I don't know that I buy that. Who knows who knows what's going to happen? I mean, I would be shocked if they come out and basically destroy all software patents. I would be shocked if that happens, but it could happen. I don't know if Matt has a different opinion about the huge impact on it.
Matt, give us some context. How are software patents even implicated here? Isn't this more of a business methods case? And, how are those two things interrelated?
Well, the fundamental question is, can you patent a process? And if you can, are there certain limitations on which processes can be patented? The Federal Circuit said you can patent a process as long as the process is tied to a particular machine, or carrying out the process results in some sort of transformation of matter. Think about a process that you do in a factory where you're bending boxes to form a package or something like that. That would satisfy the transformation of matter prong of that test. But these processes that don't meet either of those tests, are they truly just mental processes? And if they are, should they be patentable? Or actually, should they qualify as patentable subject matter is a better way to say that.
Right.
Whether or not it's monumental, as Gene points out, certainly it's a very important decision. Anytime the Supreme Court speaks on patent law, it's an important decision. But I'll put it in this context. I've been practicing now for about 10 years, and I was told at the beginning of my career that Festo was monumental because the Supreme Court was going to speak. I was also told that KSR was monumental because the Supreme Court was going to speak on it. And now we're being told that the future of innovation depends on Bilski. We got through all those cases, and I think we'll get through this one too, no matter what happens.
Mm-hmm. So where do we stand now with Bilski? We have a Federal Circuit decision that has called into question the availability of this sort of a patent. And we could spend hours discussing, why it would be questionable, but it has essentially to do with the obviousness of the process. Is that
no? It's actually no. It's that would take it to the level of whether or not a process is novel and non-obvious. We're not even at that point. The issue here is whether or not it qualifies as patentable subject matter. Mm-hmm. So whether or not it's
you don't even get there.
Yeah, if you don't even get to that question. And procedurally, we've got an en banc opinion from the Federal Circuit, so it is a big deal. Mm-hmm. And the Federal Circuit's the one that kind of brought us back to this machine or transformation test. And the Supreme Court now is considering whether or not they erred when they did that.
Right. You guys listened to or read the transcripts of the oral arguments on this in the Supreme Court, and do you have any guesses, Steve?
Yeah, I mean, guessing what the Supreme Court's going to decide is that's crazy talk. I have no idea. Like I said, I would be stunned if they basically do away with all business method, and software patents, and they're related enough, in that analysis that whatever decision they come out with is most likely going to impact both. Mm-hmm. But yeah, I wouldn't want to guess. Probably what they're going to do is, in their analysis, they're going to come through and define. They'll go back to the earlier case law and do a better job of defining exactly what 35 USC 101 covers. And it may be similar to what the Federal Circuit's test is. It may be completely different. Who knows?
Right, Matt. Any you want to toss yourself out to the wind here and hazard, I guess that's what we're waiting for?
I've gotten out of the game. I'm guessing what the Supreme Court's going to do. I don't know. It's, if nothing else, Supreme Court or Bilski's been a great reminder of how the Supreme Court works procedurally. They'll announce the case when they decide they want to announce the case.
Right.
And we kind of just have to live with that.
Won't it be funny if it's just this short, succinct opinion and there are no dissents? And
well, that's the interesting thing that you bring that up, because as we near the end of this term, there's some talk now that of the Supreme Court kind of just punting on the issue. There's apparently a procedure that they have where they can basically kick it back to another vote of cert, and if they don't satisfy it this time, then the case apparently can just get punted.
Oh my gosh. So they would have, next term to take it up again?
If it survived that cert vote again.
Yeah. Wow. That would be interesting. And let me just ask you, I saw a fascinating Mo Rocca piece on CBS News Sunday morning discussing the fact that the first to market sleeved blanket manufacturer was actually the Slanket and not the ubiquitous Snuggie, because he was somehow unable to patent his brilliant sleeved blanket design. Are we somewhere in the same realm of the subject matter simply not being subject to patent?
No,
how on earth can we have these two competing and nearly identical products on the market, given the fact that we live in a patent system here in the U.S.?
I would say with the name Slanket. Did you say Slanket?
Slanket. The Slanket, yes.
The Slanket with the name.
Blanket. It's a portmanteau.
Hey, if Becky Worley can talk about ShamWow on her show all the time, I can bring up the Slanket.
With the names, with the brands Slanket and Snuggie, I would say it's a trademark issue. I think somebody won the brand war.
Yeah, I don't know. I mean, they basically glossed over the patent issue in the story and said they simply couldn't get a patent on it. So, when they weren't able to, to carry through on their marketing to the extent that Snuggie just was everywhere.
And they somehow decided that it had nothing to do with the name Slanket.
Maybe.
Well, it makes me feel better. We had one of our secretaries had actually had a blanket and some binder clips and had kind of mocked herself up one that she was using at her desk one day, and we kind of passed on filing a patent.
You are in Idaho after all. Snow drifting up to the doors of your office.
That's a pretty good cue. You better turn up the heat. So, and they're making their own Snuggies out of binder clips and blankets. So
I don't know. All I could think was that it possibly had something to do with what we discussed a couple of weeks ago on the show about copyright and fashion, that there are certain areas of the law where intellectual property is treated differently than others, and perhaps sleeved blankets are one of those carved out. But I just had to, with my two patent experts here on deck, I had to just get your quick take on the Slanket versus Snuggie debate. Anyway, so let's talk. We talked a bit about Apple in the course of the iPad. Always fun to check in on their various patent disputes and patent issues. Somebody who was not able to avoid calling their blog Patently is Patently Apple. And they had a fun post about the various patents that were impacted by the iPhone 4 with its new gyro technology and its video capture and video conferencing. I don't know that there are any legal issues there per se, except for Apple and Nokia and HTC are all suing the bejesus out of each other. You guys, Steve, any thoughts about Apple's situation and multi-touch and all the cool things that they're doing?
I mean, it shows you for players like that patents become kind of a nuclear arms race where they're really building up for defensive purposes. So when your competitor sues you for something, you can countersue them and the whole thing goes away. And because of that, every last little innovation and change they come up with in these, they file applications on. and they're getting patents on them. So it's interesting to see how all of this happens and how these large corporations with patents are using them against one another to get cross licenses of the technology they need.
Steve, do you think that could also have to do with a strategy for combating trolls as well? I mean, not just the HTCs and the Apples of the world fighting, but the the Apples and the Ray Nero kind of people of the world fighting. Could that have anything to do with it?
Yeah, I mean, I don't, with a troll, a quote unquote troll, doesn't do anything you can countersue them on. They don't make anything, they don't use anything, they don't sell anything. And so it's pretty hard to assert a patent back against them. And that's, a lot of those large corporations, their patents, IBM, Sun, they're really using them for that purpose.
Did you guys see this little blip from the ABA Journal about the guy who bailed on Kirkland and Ellis to form his own basic patent trolling law firm? I've seen, obviously there are companies that do this. Now apparently there are law firms that do this. And they're going to pursue their own patent portfolio, which they've purchased 4,500 of them, and as well as suing to enforce other folks' patents. So just keeping it all under one roof. Is that what all the jockeying about mobile devices essentially boils down to, as Evan was pointing out? It's all just strategic? What do you think, Matt?
I think so. I think so. Like Steve said, whenever there's a successful product in an industry that's got some well-defined competitors, the patent infringement lawsuits inevitably follow. And like Steve said, they usually end up settling by way of cross-licensing.
Right. Okay, so
the real problem,
sorry, go ahead.
The real problem in the industry isn't that Apple invented this new way of using a gyroscope to, and somebody else later on, a competitor later on, starts using that. That's not the problem. The problem is when you have somebody that filed a patent application 10 years ago on a completely unrelated technology, that they're really stretching the claims to define it in a way that covers Apple's gyroscope. That's what really gets people upset. And that's what a lot of the per se patent trolls are doing. They're going out there, they're finding patents, and they're really twisting words to make them cover technology that wasn't invented for another 5, 10, 15 years.
Well, you guys have supplied me with some great resources that will feature as our couple of resources of the week for this week's TWiL. Matt, do you want to tell me about what Google and the PTO are up to?
Oh, sure. The Patent Office and Google have made an arrangement where Google is going to supply patent data to the public. In a nutshell, it's patent data that was previously available through the office, but if you wanted it in some sort of bulk form, the only way you could get it from the Patent Office was to pay for it. And it was not a small amount of money either. The Patent Office has basically, over the last year or so, I think, come to the realization that they don't have the manpower and probably hardware to deal with the increasing number of requests for data that are coming at them. So I think the Google thing is kind of a Band-Aid solution to get the information out there faster and give it to somebody who kind of can deal with the demands that are being made. I remain hopeful, though, that the Patent Office is going to kind of create its own system, because that's actually what we need. But that's what's happening. You can go to Google now and you can download bulk patent data, which is pretty cool.
Right. So folks can find that at google.com/googlebooks/uspto.html. Have you kicked the tires on it? Is it useful, or is it just kind of a mess of data and there really needs to be some other layer to make sense of it?
I haven't really kicked the tires on it, but I have looked at it, and my first impression was it looked like it was just something that was just thrown up there. I mean, it looks like a pretty basic interface, and I don't know how easy it will be to get the particular data that you're after. The PTO for years kind of bound things up in archive-type files, and if you knew where they were, you could kind of you could find your way through the servers and extract them. I think Google, to start, has just taken those files and put them up, and they're linkable, so you can just download them with a click.
Great. And along these lines, sorry, Steve, were you going to say something?
how they provided it, it feels like what you get in response to a discovery request, just boxes and boxes of stuff to dig through. It's a whole bunch of zip files.
Thank you, Google and the USPTO for that.
It's bulk data at its finest.
Yes. Well, I guess bulk data is better than no data, but it sounds like...
But it's free.
Yeah, it's free, and that means, those who want to make a market out of this can go forth and do so, I would think. And so, Matt, along these lines, why do we need an open, reliable, and fully documented API for interacting with USPTO data?
Like I said, before this announcement, the Patent Office, all this information is stored at the Patent Office. Information about patents, the number of patents that were granted during a period or to inventors in a particular state, or on a particular subject matter, expiration dates for patents. All that information is stored at the Patent Office, but it is not accessible in any way, shape, or form. Even the information that you could get, this data that has now been transferred over to Google, was put in these kind of arcane text files that were zipped up, and you had to write scripts basically to traverse through those and extract out the data that you wanted. Over the last, I'd say 5 to 10 years, there's been kind of this explosion in websites and other apps that are purporting to analyze patent data and draw conclusions on that. And, you've seen some of these websites where you can go to a website and say, hey, I want to know the patents that were issued in the state of Ohio for the last 2 years or something like that. When you write those apps, the way the data was locked up at the PTO, they were highly dependent on scraping routines. So if the PTO changed the way they presented the data, the whole app would kind of go wonky on you. So I think the Patent Office, as the holder of all this great information, which in Gene Quinn's words is monumental in importance to our society, I think they need to present it in a way that people know how to interact with it, and they teach people how to interact with it. And when they're going to change that, they tell us about that, and they document the changes, and so on and so forth. And I've been harping on the office for a few years about that because, not coincidentally, the Patent Office actually has a statutory duty to get this patent-related information out to the public. That is absolutely their job number one. And, I harp on the office a lot, but I think that's the thing where they're failing miserably on, and they need to improve.
All right.
And I think part of it...
Sorry, Steve, one more time.
I think part of it plays into that is because the fees they wanted for the data were so high, and couple that with the fact that they had limitations on how much data you could actually scrape from their website a day. Those rules are probably still in place. And if they had caught you scraping more than it's like 100,000 hits a day, they would actually ban your IP address. And there were times when the USPTO site would have connectivity issues, and I know a number of times they had blamed that on overseas entities that were basically scraping the U.S. Patent Office's data because they didn't have an API that could be accessed. And to some extent, they've moved that burden to Google now, and they've just taken that data and said, "Hey, it's over there. Have at it." Right. To where people that are wanting to build third-party sites and trying to build up collections and ways of sorting through patent data can now not have to hammer the Patent Office's website to get that raw data.
And ultimately, wouldn't this make the patent attorney's job less difficult, more efficient, the ability to search for prior art using more enhanced tools that can cull through the information that's out there rather than more so-called manual techniques that you'd have to rely on now? Isn't that really one of the things that could be hopeful, that could give us hope from an endeavor like this?
Yeah, that's an interesting point. Go ahead, Steve.
I was going to say, sure. I mean, if you go to the Patent Office's website now and you search for a patent, you find a patent, and you want to view the images of it, up pops a box that'll try to load Apple QuickTime. For me, I can't get it to work on any of my computers. I cannot view patent images from the USPTO because they are in TIFF format, not in PDF format. That ability, Google has a patents database that you can search that has PDFs. that's a wonderful thing. But getting that information out to where it can be more easily used and converted, it has great benefit to patent attorneys.
Patent attorneys, in addition to our technical people, engineers and inventors, being able to easily extract information about prior art, other people's inventions, watching their competitors, that kind of thing. Like Steve pointed out, I think it's a perfect poster child for the state of affairs we're in. You cannot go to the Patent Office website today and download a PDF of a patent. Can't do it.
That just seems, completely out of whack.
It's pathetic.
Yeah.
Mm-hmm.
Well, one thing the Patent Office, which is also the Patent and Trademark Office, we should point out, has done is try and disintermediate the likes of trademark lawyers like our friend Marty Schwimmer a bit by putting out its Trademark Information Network, our second resource of the week. Steve, you want to tell us what this does?
If you look at it, the Trademark Office is working on coming out with a number of videos and walkthroughs and help files to allow trademark applicants to do a better job of filing their own trademark applications. And I think if you made your bread and butter was just filing trademark applications as a practitioner, as an attorney, you're probably not happy with this website. But I think the reality is that there really is a need, whatever the area of law. Certain people don't have the access to lawyers just because of the cost, and for them, any place where lawyers or the Patent Office, for example, can make it a little bit easier to understand the process, and if they want to do their own job of filing pro se applications. It's a great thing. And there's a number of services out there that have tried to fill that void. All of the forms businesses that you'll find around town selling wills or selling, $99 divorces. And then services like LegalZoom that offer, real inexpensive ways to do things. The issue that comes up with this is if you look at it, you look at what LegalZoom does, and you look at the walkthroughs here. I think the real people that are going to be harmed through this are people like LegalZoom. Because it's like, do you want to pay LegalZoom for the forms that the Patent Office gives you for free, and the walkthrough and the explanation the Patent and Trademark Office gives you for free? I think it's a huge change. And some of if you look through it, they're gradually working on videos explaining every step of the process. That's what's up now. And one of the great things, there's a couple timelines that maybe you can link to that walk through both the in-use and the intent to use trademark process. They're just flow charts that say this happens, then this happens, then this happens.
Right. Trademark application and post-registration process timelines that you sent me.
Yeah.
They're in our show notes if folks want to take a look. And,
those types of resources are great, and I do a fair amount of trademark work myself in trademark prosecution and some infringement litigation. But there's a certain amount of prosecution work that I do, and I'm not concerned about this cutting into my business whatsoever. In fact, I think that it will make the experience one of much greater quality because I trust that you all have this same impression too of dealing with those who you're representing. It's much more meaningful, much more productive. I think everybody's happier when the client understands what is going on and what the process is going to be like, what the relevant issues are. And so a tool like this is one that can quickly bring the client up to speed on what the ball game looks like, how many quarters of the game there are going to be, what the rules are, and it saves legal counsel a lot of time from going over some of the more rote facts that deal with trademark prosecution, like you've got to file the application. It takes 3 months for the examiner, 3 to 5 months for the examiner to start looking at it. You might get an office action. Here's what an office action is. It's 6 months. A lot of those more mundane details of the process can kind of be in the mind of the client before coming to trademark counsel's office, and then you can really focus on really hitting the important legal issues, the thorny issues and clearance, and all of those wonderful things that counsel can really add that cannot be
absolutely
derived.
And I don't think for a second that this would disintermediate the likes of you and our friend Marty, who add so much more intelligence to the process of how someone would manage their trademark and brand above and beyond the whole registration process. This seems to be just the beginning of the conversation here, but there's much more to that you would go over with a client.
Right on.
So thank you so much for those resources. And we'll go on to our last story, which also happens to be our tip of the week. And the tip around this is, if you zealously guard your intellectual property, don't have storylines depending on mashups and copying. And this was a really wonderful post over at the Balkanization blog by, let me get her name here, Christina Mulligan of the Yale Information Society Project, called Copyright, the Elephant in the Middle of the Glee Club. So with the final episode, season finale of Glee this week, Christina has pointed out that the new directions, or the nude erections, if you listen to one of the Glee cast's appearance on the Jimmy Fallon show, I thought that was a wonderful little insight into their writers' brains. Their writers are quite funny and creative, and they certainly have no compunctions about having the folks in the Glee Club do mashups and basically adoptions of other videos. There was the Madonna one, featuring Sue, the cheerleading coach, and let's see, also the Olivia Newton-John one with again Sue. So Christina's piece here is fantastic. It goes through and documents, each of these little infractions and how much they would rack up in damages if we were living in the real world and the rights holders were to come along and decide to sue. So it's an interesting paradox to have something coming out in the mainstream broadcast television format that basically is encouraging. There are Glee clubs at high schools all over the world who are going to look at this and want to emulate these folks and do exactly what they're doing, and could get them in a lot of trouble. Evan, did you find this kind of funny and ironic?
I did, and I can't look at the camera because I'm still blushing. You said new directions, but
It was my Beavis and Butthead moment for the show.
I think it may take me on through the rest of the show. I'm not going to be able to think straight. This is really funny, and it is kind of interesting how I love things that are recursive, and so when you see little stories within stories or little scenarios within scenarios like this, it really does kind of enhance the humor of it a little bit, and it perhaps shows a little bit of hypocrisy or maybe short-sightedness on the side of big content like this. So it's a very apt effort, to point this dissonance out. I like it. It's funny.
Matt, are you a Glee fan? And this hadn't even occurred to me that it did kind of in the fact that I guess the full force of my legal thoughts while watching Glee were just, how, they're doing mostly covers. So I could see where they're okay there as far as needing to license their works. But, they do go beyond that. What do you think about all this?
You have to be able to turn it off sometimes, and you're not analyzing everything.
Yes.
I must confess, I've never watched an episode of Glee, despite the urging of many friends and family. The issue is interesting, though, and my first thought is that copyright law maybe it's becoming more like patent law. Most people in patent law, the patent owners, someday you're an infringer, and some days somebody's infringing your patent. And nobody seems to have a problem with that.
Yeah.
Yep. Changing hats. Steve, any thoughts about Glee and the RIAA and its cognitive
and obviously they're paying, they're paying copyright on that. The network is, but it's you're right, when your kid's school does the same thing, they've got some problems with that. And there's a great book, and I can send you a link to it, that was written by a professor in Oregon, I think. And it's, it's like, 8.5 by 11, and it's 100 pages long. That's written particularly for schools on copyright issues, and that's one of the books that I always buy the kids' school whenever the kids have a new school. Buy them a copy of that book for their own library, so that the principal can look up those issues as they come up. How do you handle this? How do you handle photocopying? How do you handle all these various issues? So
yeah, I'm pretty sure Will Schuster hasn't read it. But, maybe there's always next season, so we'll see. Folks, it's time for us to wrap up. Much as I would love to chat on with you, we'll certainly have you guys, Matt and Steve, back on the show after Bilski, your schedules permitting, to bring us up to speed on whether this case is going to shake up the world of patent law or not. And in the meantime, enjoy yourselves, and thank you so much for coming on the show. Steve Nipper, folks can find you at Nipper on Twitter.
Correct.
And we really enjoyed you, as always, as a guest on TWiL. Also, we've got, our pleasure. And Matt Buchanan would be at jmattbuchanan on Twitter.
Thanks for having me, guys.
Thank you so much for coming on. And Evan, if you're able to speak yet again, thanks again for coming on the show. I can't tell if you're just sunburned from Florida or still blushing.
A little bit of both. Remember how Beavis would have like those little bubbles coming off of his head when he would, put the t-shirt over his head. But yeah, thanks for having me. Great time. It's great talking with Steve and Matt. These guys are definitely at the top of their game. Definitely, they're the go-to people for patent stuff. So it's been a real pleasure talking with them today. So really enjoyed it. Thanks.
Me too. And folks, do go follow Evan on Twitter as well. He's at Internet Cases. I'm at D Howell, and you can email me after the show, Denise at twit.tv, with any thoughts, or you can ping me on Twitter. I check there all the time. Also, bagandbaggage.com is my blog, which tends to confuse people because all I really ever post there are witty things my son and his friends say and videos of this show. But every now and then people figure out that, yes, it is the same person who hosts TWiL. So just to clarify that, thanks so much for joining us, and we'll see you again next week for TWiL 65. Take care, all.